Hey guys, welcome to another episode of the Texas Blockcast. I'm excited about this, and we have a very timely conversation in the legal world, in the world of digital assets, that with my friends and colleagues and members of the TBC, Alex and Monica, who lead the digital asset practice at Carrington Coleman, early members of the TBC. In fact, Alex and I were reminiscing. We connected 4 or 5 years ago, before the TBC existed. Maybe it was about 5 years ago then.
Yeah, I mean, and just a quick shout out for Lee and the TBC, just one of the best trade organizations in the crypto space nationwide, and certainly in the history of Texas. I mean, we had seen other organizations come and go, and was so excited to start working with Lee when he was still a professor at DBU, and then now full time here. Definitely found your calling, and we're doing the right things in Texas.
Well, I appreciate that. And that's funny. Probably a lot of people don't know what I was doing before this. So yeah, before this, I was a political science professor, which has a somewhat of a segue, right? Because it's policy and politics. But yeah, we were putting on gatherings of interested parties who saw the friction. They saw friction, and we all saw the friction in the community with elected leaders and traditional elites. And they were missing each other. And we would gather executives, probably 20 or so, usually maybe 15. You came to several of those meetings.
Yeah, you're speaking our language. A lot of what we see our role in as crypto lawyers is bridging the gap between entrepreneurs who are building these amazing technological solutions and finding a way to kind of bridge the gap between them and the legal structures that already exist, and the many frustrations that we've all gone through in trying to bridge that gap.
It's an act in translation, right? Like we are sort of bilingual a little bit. We speak traditional, and then we also speak crypto, and so you kind of have you mediate and you translate between the two, because there is some translation that goes into that process.
Right. I would say maybe trilingual, because then you've also got the legal parlance and vocabulary, traditional finance, and crypto. So you guys are like walking, three type roads at the same time.
This is our charge.
And so for the conversation today, I'm really excited about this, because we get to talk about the news that broke this morning. When this podcast airs, it'll probably be 48 hours old, but the SEC suit, Binance and CZ. We're going to chat a little bit about the a couple week old, maybe a week or two old information that came out of Congress from a joint legislative effort from leadership in the House Ag and House Financial Services Committee that would really transform the policy landscape for the digital asset industry. And then we're also going to talk a little bit about DAOs, Monica's specialty, and some legislation that we nearly got across the finish line in Texas, passed the Texas House, but just ran out of time to get it through the Senate. So that's the agenda. We'll probably go on a lot of segues, which is going to be great. But you guys are some of the sharpest legal minds in the space, and so it's a real privilege to have you guys on. Really appreciate it.
Very
Thanks,
excited.
Where would you like to start?
Let's start with the news of the day. So your feelings about this SEC lawsuit. We get a lot to unpack here.
It's interesting. So I guess let me start by saying we've been seeing this coming for a long time now. In fact, there were several web scraping tools that I used to try and find what the latest crypto legal news is, and they were reporting even last week that the SEC had filed, which the file stamp was as of today. So query how it is. Some of these news scrapers got advance notice, but be that as it may, I've had a few minutes before we were able to go on air to briefly peruse the SEC's complaint, and it is a whopper. It's over 160 pages long. It's against a variety of Binance entities and then CZ individually. And in terms of the content of it, a lot of it isn't particularly surprising. It's very consistent with what the SEC has been alleging in similar lawsuits, for example, against Kraken and others, where they are alleging that the fundamental problem that Binance has is it is serving as multiple kinds of entities that we would normally see in traditional finance, or TradFi, as you were about to say, and commingling them. So they're acting as a broker-dealer, they're acting as an exchange, and they're acting as a clearinghouse, and they're also custodying customer assets and commingling them. And, from the crypto industry point of view, this has been problematic, and we've seen this, for example, in the Coinbase litigation, where parties like Coinbase have said, hey, look, we have been trying to find a regulatory path to compliance and to work with the SEC and to work within the rules, but the rules contemplate an outdated model of transaction flow, where one of the fundamental innovations of blockchain, for example, is real-time settlement, where you don't need a clearinghouse function and you can confirm trades immediately on the blockchain. But separate and apart from that, there's this question of whether Binance is operating as an unregistered broker-dealer, an unregistered exchange, and an unregistered clearinghouse, which presumes that they have been selling unregistered securities. Mm-hmm. And as the audience is probably very well aware, this is, in my view, the single most important legal issue in the cryptocurrency industry today, which is this question about which digital assets are securities or not. And there are several that are named in that complaint. I have not taken the time to familiarize myself with all of them, but several of them we've already seen named in previous actions. For example, Algorand, which is a really interesting one because there's some footage of Gensler when he was teaching at MIT, seemingly suggesting that Algorand would not be a security, and yet now here we are alleging that they are.
Well, it's a day that ends in Y.
Well, I mean, and this goes to, which will bridge to this other conversation, but for those of you who watched, I've watched entirely too many congressional hearings on crypto, but if there's one to watch for the audience, I highly recommend. There was a financial services hearing where Gensler was a witness, and right out of the gate, Chair McHenry very toughly cross-examined Gensler on the question of, is Ethereum, the second largest market cap digital asset in the world, is that a security? And Gensler couldn't clearly answer the question. He just reverted to the Howey test analysis and you don't want me prejudging and this hemming and hawing, which McHenry criticized as this regulation by enforcement, where we in the crypto industry don't have the clarity the SEC claims that we ought to have, and instead we're finding out case by case which digital assets the SEC is considering securities. And here now we have a new packet of examples, as they pleaded, which include Algorand, and as I understand it, also Solana, and at least several more. And so this will be a key battlegrounds, because whether, we'll all read the complaint, and the complaint has a lot of internal emails that are the result of the SEC's investigation, some of which are problematic for Binance if they are true. But we as the industry as a whole, whether you like Binance or not, Binance is now in the position of litigating some of the key issues which are facing all of us. And one thing that's become very apparent to me as a crypto lawyer in the space is we benefit from trying to have a unified front to the greatest extent possible to advance friendlier and clearer regulation and legislation when it comes to crypto. And for better or worse, this is now Binance has entered the fray, and I think that we'll see in the coming days and weeks what their response is, and be able to better assess how it will impact the whole industry.
When is their answer due? They've got, 30 days?
Yeah, so the filing came through today. So in the normal course, assuming Binance has accepted service, I think that would be correct.
No, 60. It'll be 60 days. 60, federal.
Yeah,
it'll be 60. So a couple of months, a month, 2 months, till we hear what they have to say.
If they don't publish earlier, because one other thing that we saw with Coinbase is Coinbase got this Wells notice, and companies are not under a per se obligation to immediately disclose that they got a Wells notice. Coinbase made a strategic decision to kind of litigate in the public and publicize that they'd received the Wells notice, publicize their strategy, and kind of declare their intent to fight this fight, and makes for a great rallying cry for many in the crypto industry. And right now, I think it's too early for us to judge what Binance's response is going to be, but as it matures and as they release statements and we get to see, we can assess what the impacts will be for the industry.
Yeah, because Coinbase is a different actor altogether, right? Very much a U.S. company, a lot of disclosures, publicly traded, all these 10Ks and all this stuff that they've been filing for years. But help me understand with their strategy. They are going to argue that these assets that are traded on their platform are not securities, or are they going to argue there's three things that they could argue. One is that, or the other is this middle ground, is that a lot of them had Reg D offerings, but then now trade as just an asset that are separate from that initial securities offering. And then the other might be that, well, I don't know. Y'all, what is their tactic, their argument here?
There are several really important things in what you just asked. So let me answer the last question first. Coinbase's position unambiguously is they don't list securities. And they have a framework that they use internally to evaluate and assess whether the digital assets they list are securities or not. They stand by that analysis. They apply it. They apply it before they list tokens. And to your point, Lee, there is a thinking in the law that something that may begin as a security may in the future no longer be a security, may be a commodity in the hands of a different user who is purchasing and using that digital asset for some utility values, for some service on a particular platform. And that could very well be part of the argument. But just to answer the question, for sure, Coinbase's position is we don't list securities, and we do an analysis to prevent that. But I want to.
But they do list. I just am curious to know, have they published what that framework is that they use? Because one time I tried to look it up and I couldn't find it.
I don't know that they've published it in full. I think they have described it in some of their releases, but I mean, I would imagine that they produced it to the SEC at some point.
Yeah.
But I've not seen the full analysis.
And I think they are the best horse for us to all get behind, if you will, as far as the actor that the community needs to rally around. And that's to your point too, is let's ensure that they have, the backing of the industry, because what gets the precedent that gets decided in this case could be quite influential.
Correct. So the overall conflict that we have right now has many fronts. Everyone likes to talk about the Ripple case. For sure, if we got a favorable result in Ripple, that would be incredible. But that's just one case in one court and one data point where, more likely than not, whoever wins, there's going to be an appeal, and that process is going to get drawn out. Whereas Coinbase, to your point, they're a public company. They have a very long history of trying to both lobby both for federal legislation and for rulemaking from the SEC. They have their own suit alleging that the SEC has failed to make rulemaking which would allow them to comply. All of that is going to be in play. And again, to your point, the crypto industry as a whole benefits from rallying behind practical solutions that we can see ultimately adopted by the federal government, both in the regulatory bodies and in the legislature, to hopefully create, to bridge the gap where right now there's just this cloudiness and murkiness which prohibits many, if not most or all of the industry from being able to have any path to compliance. But I want to come back to one thing that you said earlier, this difference between Coinbase as a US-based company and Binance, because it is really interesting. There is a strategic consideration that I've heard other people argue on Binance's side of things, which is part of the kind of founding values of crypto is in this idea of decentralization, and the idea that Binance intentionally and strategically chose not to have kind of a single geographical locus to be more distributed. And there is something about that from a basic conceptual framework that sits ill with some lawmakers and some regulators. They feel like, well, the only reason to obscure your location must be because you're doing wrongful things. And I hear this argument all the time in the context of free speech and privacy rights. Privacy being the prime example, where people say, well, why do you need privacy? Privacy is only privacy to commit crime. And to think that is to ignore the intrinsic value of constitutional rights that we enshrine and we protect. And privacy has to be worth something more than just the privacy to commit misconduct. There is an intrinsic good to that, and so I don't know how much we'll see that get played out in the Binance litigation, but it's a point I wanted to raise because I think a lot of people ascribe negative intent or malice to the idea of trying to be distributed and trying to avoid having a geographic locus, but there are some ways in which I see that as consistent with what you might call founding principles of crypto.
It's fascinating. What court is this? Is this going to be the 13th Circuit or?
It's in D.C. District Court right now.
D.C. District Court.
Yeah.
Okay. For both cases, I would assume, because anything.
The SEC, the Coinbase lawsuit against the SEC, isn't that pending in the Third Circuit?
So, I believe that's correct, which is Southern District of New York.
No.
No, that's Second Circuit.
Yeah, Second Circuit. Third Circuit, I actually don't know off the top of my head.
But then the Coinbase complaint about the failure of SEC rulemaking actually, I believe, went directly to a court of appeals.
That's the Third Circuit. That's what I'm talking about.
Yes,
yeah.
okay. But then there's the Wells notice, which hasn't become a lawsuit
which hasn't
yet,
become anything.
so
So that we don't know where that
TBD
will
with
land.
TBD.
So
Okay.
you've got two different circuits which don't have to agree with each other, which also creates an interesting dynamic, right? And honestly, I don't know that the Third Circuit will think, oh, well, we want to wait to see what the DC Circuit. Like, I don't know that will happen. Some courts are. A lot of federal courts don't particularly care what the other federal courts do.
Right. Is the 13th synonymous with the D.C. Circuit? Is that the same? Because aren't there 12 circuits plus the D.C. Circuit?
There are not 10 circuits: the Federal Circuit and the DC Circuit. The Federal Circuit is IP mostly. I think there are only 12.
Okay. I'm a little off there.
And
Reaching back very far into my
Yeah.
into Fed courts.
that was a
But
good
I know
question.
I know Texas is 5th. That's what I know.
Yes.
Yes, we are the fifth.
Louisiana, Oklahoma,
Yep.
so maybe, I don't know,
Correct. Which
3 or 4 states.
so many fun detours and tangents on that. But what I think this really begs an interesting question of is, does one of these cases make it to the Supreme Court,
Okay,
right?
yeah.
Because again, you've got Ripple, which is in the second in the Southern District
Right.
of New York. So you could have that appeal to the second court. You have this other one, which is in the third, and then you have lots of these lawsuits all across the country, and the possibility of inconsistent results. And with the Supreme Court ruling the way it's been ruling, I think that you might get a very fresh and novel take on some of these questions if they were to take one of these cases.
I mean, the Supreme Court just came down and said, maybe we're going to reconsider Chevron deference, which is like a shocking, that sort of deals with administrative decision making and rulemaking. And there's been a lot of, over the course of many years, deference to that decision making. And the Supreme Court has just basically announced, we'll take a look at it and we'll decide if that's still appropriate. And so I think there's a little bit of an
that would be,
appetite.
again, that would sort of hamper the SEC.
It could affect this. It's a little bit of a different. It's an analogous situation, but if that's their inclination and they decide to open that Pandora's box, frankly, it could lead to very interesting positions on some of this SEC enforcement actions. And so, I mean, frankly, I think it's inevitable that one of these will be at least appealed to the Supreme Court. Whether they take it is a different story. But 2 years ago, I would have said, oh, they're not going to play in the sandbox. But now it's possible that they would they'd put their hat in the ring, and then the question will be, whatever happens, somebody will not be happy with it, and then maybe that will push the legislature to do something if they can't get some decent regulation in the interim, which is a big question mark.
Well, that's a good segue to our second topic, which is this potential legislation. If it's say first, let's answer this, and then we'll talk about what it actually is. If the Patrick McHenry Ag Financial Services bill were to pass the Senate, which we think it could probably pass the House, but the Senate is another thing entirely, and were the president to actually sign it and not veto it, how does that affect these lawsuits moving forward, or does it affect it at all?
It will not.
Okay.
It doesn't have a retroactivity aspect.
I haven't looked to see whether it would have retroactive application, but in general, what this proposed legislation would do is create a path for registration for digital assets firms and an exemption from the definition of securities under certain circumstances. In general, that if the digital asset is sufficiently decentralized over the previous 12 months, then it could qualify under an exemption. And then for certain types of preliminary registration, there's protection so that you can't be prosecuted for the sale of unregistered securities if you are complying with the application requirements. And so that
So it doesn't make it a commodity; it just makes it
Not a security.
a security that is, what's the word? Not subject to traditional securities filings.
Well, and to be clear, one outcome of the new proposed regulatory framework would be digital assets that are qualified as commodities and would have to comply.
But you could have three categories, right? You could have commodity, a security that's exempt under this new category, and then a straight up traditional security.
Correct. And so to be slightly more clear, what the proposed legislation does is it requires the SEC and the CFTC to cooperate and exercise some degree of joint jurisdiction over treatment of digital assets. And so we're not talking about creating a new department. We're not currently talking about what's called an SRO, or self-regulating organization. We're talking about a mandate from Congress that the SEC and CFTC collaborate on rulemaking along the lines of what's proposed in that legislation. And that would involve carving out certain securities jurisdiction and then creating a pathway for compliance both with the securities laws and with the commodities laws. There's one other thing I wanted to pick up on, which was very important in all of this, and that has to do, and now, of course, it slipped my mind, but it'll come back, and it was a brilliant thought, I promise.
I'm sure it was brilliant.
Just interrupt me whenever that comes back, because we want to make sure to be the ones that break the news on this on this thought. Okay, so I'm grasping what this, and it makes sense that it would not be retroactive because there are things that you have to do in order to qualify for this, which obviously a lot of these other assets did not do and could not have done. But maybe if the legislation passes, it makes a judge a little bit more amenable to a favorable outcome because he knows, or he or she knows in the future, that's what that's what their intention is, the legislature's intention is.
That reminded me of what the thing is.
Oh,
so the exemption from prosecution for securities laws violations is specific to registration, not to fraud. Okay.
Oh, sure.
So nothing prevents the SEC from prosecuting securities fraud cases against digital assets that they deem to be securities, which is an important thing to flag. But to your point, I think this goes to one of the fundamental questions here is, what is the purpose of securities laws and commodities laws? And generally speaking, it's to make sure that investors who purchase securities have received full and fair disclosures so that they're able to make informed choices about what they're buying and selling. And so, the issue is, as has been flagged in these congressional hearings, disclosures for traditional finance are not necessarily the same disclosures that would be material or important for digital assets. So-called tokenomics, the governance structures, things like that, the way the smart contracts work, are not things that are necessarily contemplated in a traditional finance filing. And so, one thing to think about, and one thing that we work with our clients on, is if you read the writing on the wall and you say, some form of legislation like this is likely to pass, what can we do now to start getting our ducks in a row, start making these disclosures, start building a platform that can comply with what we anticipate the future regulation is likely to be? How strong of a defense will that give you in current litigation? That is a big question mark, because you're still going to be held to the standards of current existing law, but it's going to be a relevant consideration when you may be faced with allegations of not making full and adequate disclosures. And you can say, well, we've done the best we can under the current framework and anticipating what we think the requirements should be for digital assets. And that's going to be one of the things that we're facing.
And I think that argument will become stronger if and when legislation is passed. I think when it's prospective, it's still up for, this bill has a long way to go, obviously. But if it were to pass, and, we've been talking about 2 years as sort of the litmus test, but maybe sooner. I mean, it is some progress, which is good. But if it were to pass, I think then you have a stronger point. I mean, judges do take that sort of thing seriously, right? Like if they're going to be deciding a case that they know that there's legislation out there that is countered, like that's a consideration I think that judges will take. I mean, this is kind of a tale as old as time when litigation is ahead of legislation. It's happened over the course of in normal circumstances in other areas. Civil rights is a good example. So, you see there's a little bit of a push-pull there. And in this case, in particular, when you've got, people who on the other side who are saying, we're doing the best we can, we don't know what else to do, particularly Coinbase. I heard somebody describe them as like the firstborn child. Like they've done everything they can to play nice and appease their parents and be people pleasers. Like we just want to follow the rules and like you come after us now and like this isn't fair. Like, and it's actually a pretty apt analogy, but you put yourself in this position and then you can come back and you say, look, this is what the new state of the world is. Like you should be forward looking, not backward looking.
I want to add 2 brief points on this pending legislation. One, we've been very much involved in trying to get inside the Hill and understand the inside baseball surrounding this legislation and efforts. And it's a longer discussion than time allows today, but certainly anyone who's interested is welcome to reach out to us to discuss this further. My sense is there is a strong consensus among the Republican lawmakers in charge of financial services and agriculture to push this legislation. The current draft bill that's out there is just a draft. The one I looked at didn't even have a name on it. So there's a very long road ahead, and there are significant points of contention, as Lee noted, getting it approved in the Senate. My cautious optimism would be that what the cynics or what the skeptics are really concerned about is consumer protection and disclosures. And I think that those are solvable problems that can be addressed in that legislation. But let's just be clear, this is far from over, and the draft legislation that's out there is going to be modified significantly in committee and in further developments. And for those of you who want to be involved in this, I highly recommend you reach out because we're doing everything we can to try and be involved in making sure we have the best possible crypto legislation that comes out of this effort. The other point I want to make, which goes back to your question about how does this pending legislation affect current litigation, has to do with something I've noticed, which is it's a trend that most cases that litigate this question of whether something is a security litigate it before the judge as what's called a question of law. Judge, we think this is security. We think the law is clear. The other side says we think it's not. And then a judge rules and determines, and that's the ruling. But generally speaking in the law, whenever you have a legal question that is determined by facts and circumstances, which the Howey test is absolutely a facts and circumstances test, that's often something that goes to a jury, where a jury is asked to apply, here's the law, here's the standard, look at the facts, and you tell us, was this an investment or not? And I think that there is a strategic opportunity that people have missed in saying this should just be resolved by a judge instead of trying to take it to a jury and have a jury resolve it. Because I have a suspicion that whereas some judges may feel hamstrung by legacy case law that may be unfavorable for the crypto community, a jury may not be. And a jury of your peers may look at this and say, we don't really think this is what is supposed to be considered a security. And you may end up getting a more favorable results out of trying these cases to juries.
Now, juries are scary. Yes. Disclaimer, juries are scary.
That's not a guarantee.
It is not a guarantee, but I mean, if you get 12 people in a box and you explain to them why your token isn't a security or why what it is, and you also throw a lot of mud at the SEC for not telling you how to comply, which I think you can get away with some of those hearts and minds kind of argument. A judge isn't going to care about that, but a jury, you're saying you're here suing these people, but you're not telling them how they can comply. Like, you might be able to get away with a little bit more of that in front of a jury. And so I think that's a fair point. Like, if you want to try it to a jury, it's not a terrible, it's a good argument also to be made to say, because surely the SEC would file would try to have the law determined before a trial.
Oh, sure. You're going to have
You're
cross
going to have it
motions.
anyway, but it would be an interesting argument to say to a judge, like, dear judge, yes, we know that they want to get this kicked out before a jury, but really this is a facts and circumstances situation, and we should go to a jury as opposed to just fighting the cross motion, which kind of gums it up further.
So has Coinbase signaled, or we have no idea what Binance is going to do because this is the first day. The article I read said that Binance hadn't even received the complaint yet.
No, and they probably haven't, and it's far too early to
Yeah.
understand what Coinbase's strategy would be. But
They're a long way away from
Well,
summary judgment
yeah.
at this point.
I will offer some unsolicited advice to Coinbase, who's a new member of the TBC. We're very proud of that, and a great company. The data that we have seen about age in relation to understanding this innovation is pretty astounding. 48% of Texans under the age of 29 own some kind of digital asset. 6% of Texans over the age of 65 own a digital asset. So if it were me, and all other things being equal, even if you bring in some good points about the scariness of a jury trial, I would say, oh my gosh, the average age of a jury is the average age of an American, which is probably, I don't know what it is. The mean age is pretty young.
Yeah.
I don't know. I don't have the numbers in front of me, but I could pretty much guarantee you that the mean age of a district court judge is probably double the mean age of the average juror.
Yeah.
I think that's probably true, and as a millennial, I can confirm millennials are currently the largest living generation, so that gives you some sense of where our median age is.
There you go. Yeah, I was gonna guess in the low 30s,
Right.
That seems right. Yeah.
and that would put double. Judges are mostly 60s, 70s, right? I mean, there's some in their 40s and
Yeah.
50s, but at that level of
Yeah.
What you're really speaking to is the idea that you want a decision maker who's making an informed decision, and
time horizons and all this stuff.
and look, we have some very intelligent federal judges who are very capable of understanding the legal nuance and the technological nuance. But there's a difference between the academic understanding and the applied understanding, and the benefit of having a jury pool who may have had direct interaction and experience with digital assets could prove valuable.
That is an interesting. I'm sure they've thought of that, but hopefully that percolates.
It's not something I've heard talked about much, and it's one of the reasons I wanted to say it as something to consider that I don't see being often considered.
Okay.
Well, and frankly, Coinbase, and again, they're very far away from this stage of this litigation, but they're riding this sort of populist idea, right? Which I think is makes a lot of sense. Somebody's got to do it. There's got to be one, and so that may be a good option for them if they feel very, very strongly about their, like I said, especially with their internal protocol. That's obviously going to be a major focus of their defense. If you tell 12 people in a box that are at the average age of 35, hey, we had this internal system, this is what we were doing everything we could, you might get an interesting result out of that.
Yeah. Well, let's hope that the Coinbase case makes it to the Supreme Court before the Ripple case, because I like our chances with Coinbase much more than Ripple.
Only time will tell.
Only time will tell.
I know the Ripple case has a several-year head start, and the Ripple people would probably skewer me for saying that, but I'm okay with making that opinion public. Okay, let's talk a little bit about DAOs.
Yep.
Because, Monica, this is an area of expertise for you. We just had a DAO bill almost make it across the finish line, and almost means it didn't make it in Texas
you're not
politics.
first, you're last.
Yeah, we got a year and a half more before we can refile it. So that's just because the Texas legislature strangely meets every other year instead of every year.
I do like telling this piece of trivia to not Texas people because they think it's mind-boggling, but also kind of cool. And I do like it as a piece of as a not native Texan. I do like that as a piece of Texas trivia.
It is fascinating trivia. And it's also like people have this gut reaction to it, like, oh, that's amazing because of X, or oh, that's terrible because of X. And both are not wrong. It's like there's some great positive things about this system, and there's also some negatives. So
It just seems really hard for that for the first part of this year, for that time frame to get. It seems very, very difficult. I don't envy you that when this time period comes around every 2
It's
years.
brutal for me, but it's even more brutal for the elected officials and the staff.
Oh, that's what I'm saying. Yeah.
They're working till like midnight every night. I literally have been on the phone with state senators and state reps at midnight, and they're on the floor of the House and Senate making decisions. Like, goodness, that is insane. And then they've got regular jobs.
Right.
People don't know that these state reps make $7,200 a year.
Mm-hmm.
A year. Now, they make a per diem amount while they're in Austin to help pay for their living expenses down there. But that's not a lucrative, even if they save half of their per diem, they're still in an up net negative on this financially, which is cool, right? Because then you have to have, see, this is another one of those things, cool and not, because it's cool that they're not like just bloated, bureaucratic, there for the income, but it's also not cool in that someone who can't afford to not have an income can't run for office.
Right.
So
it creates a bar to entry.
It creates a significant barrier to entry. But I digress. DAOs.
Yep.
We had some issues on our DAO bill. You had some thoughts that might make it better. This was the DAO bill that would see DAOs be able to form in Texas under the unincorporated nonprofit association entity structure.
Right.
And
Go on.
I was going to say, because what's funny to me a little bit about this conversation is, and it is not true not all states recognize unincorporated nonprofit associations. So I get that in other states that don't have these, it would make a lot of sense. And I actually don't know if Wyoming had an unincorporated nonprofit association.
I don't think they did. No, I think it was just a blockchain LLC.
It kind of makes sense that they did what they did with their DAO bill. But Texas has an unincorporated nonprofit association statute. And so it does beg the question, do you need the extra sort of language for a DAO at all? From my perspective, I think I can make the argument either way.
Yeah.
Yes, it is good to provide additional clarity, particularly if you're dealing with lawmakers and judges who may not be familiar with the system, with what a DAO is, what it's meant to be for. Frankly, you may be dealing with a judge who hasn't really dealt with a lot of unincorporated nonprofit associations. Yeah. Or they have very negative connotations because most of those are homeowners associations.
Or ranchers.
So it's so that is one question, though, is do you really need it? Do you need a bespoke bill? But again, I think for clarity perspective, which is sort of the issue of the day, makes a lot of sense.
Because part of it is also a signaling bill, right? We want DAOs to form in Texas.
And I think that is an important, like a state competition perspective. I totally understand. Yeah. I know that Texas is, all the states are in the race, and Texas is routinely at the front, if not the front runner. We want to continue that 100%, obviously. But it makes a lot of sense to make DAOs feel like they're comfortable here. And again, clarity, from my perspective, is always good. Yeah. But there is a question of whether it is really truly necessary. And what I would say for people that are looking at DAOs that want to do them in other states for whatever reason, there are structures that you can use that are traditional structures that are much more facile and much more easy to apply than you might think they are. Mm-hmm. You can do a corporate wrapper from an LLC, and that's a very traditional, basic structure that would, I think, serve a lot of the purposes that DAOs serve. But that being said, if you wanted to pursue a DAO bill, I've looked at the one that didn't pass, and obviously the definitions and all of that stuff were great. I do question the, you must have 5,000 members.
500.
No, was it 500?
I thought, well.
Did I say 5,500? You're right. Yeah. I'm sorry. Just read this.
Too many.
It's a lot.
Yeah.
And so, there is some sense of the more you have, the more decentralized you are, maybe the more protected you are. This kind of goes to the point that we were talking about earlier with Binance, and if you're more and the new legislation, the more decentralized you are, the more you can take advantage of safe harbors. But it also raises, I think, practical concerns. It's already hard enough to get a DAO to, I mean, we saw this with the Oki DAO litigation, right? Like, they couldn't muster enough to figure out how to get service and all this stuff, right? And so I do question, and I think that limit should be lower.
Sure.
Because then also, too, it will make it a lot easier for, like, I have a couple of clients now who want to do DAOs and are interested in exploring things that aren't. Colorado has a version, and I have a client who said, "Oh, we want to do a Colorado one." I said, "Why? Why don't you just do a Texas?" And she had not something that they'd ever thought about. So, if I'm selling something if I'm saying, "Look, this is why it's great to do this in Texas," I think that creates a pretty significant bar to entry, particularly for a company that truly does want to do some kind of social good. That entity may not be capable of getting 500 members right off the bat. And so you're barring a lot of maybe some of the more social good aspects of blockchain technology, which is I think, is a big part of the community from getting in on this benefit. And so that's one consideration that I would throw out there is I think it's great for the sort of big organizations with the labs and the foundations, and we want to kind of take a piece of that market. But I think you lose out on maybe some of your more grassroots that, want to do educational pursuits or charity pursuits or things like that. That creates problems for them, I think.
Yeah, that makes sense. So a better number is closer to 100, you might say, or even lower.
You could probably, I don't really know that the number, other than the fact that I think 500 is too big, like, I don't know that going too few or too many is really the question. I think it just should be less than 500. Frankly, I think between 50 and 100 would be fine.
Yeah.
And
rest assured, we will confer before the next legislative session so we can try and help improve and get our best possible DAO legislation passed.
Yeah. Yeah, and we'll need some work in the Texas Senate on all fronts. I think that is the key linchpin for continuing to make Texas a leader in this industry or jurisdiction of appealing jurisdiction. The Texas House is very on board. The speaker all the way down to a lot of the committee chairs. The governor is mildly on board. He's been very supportive of innovation. And I would say the Texas Senate is where we have the most education to do.
Got a year and a half. Let's go.
We do. And that's the message that I'm going to be giving to the TBC members over the next, whether it's DAO legislation or some of this crazy anti-Bitcoin mining legislation that we saw, or sandbox work with the Texas State Securities Board, whatever it is, the Senate's going to be the problem.
Mm-hmm.
And
why do you think that is?
I think there's fewer of them. There's only 31 of them, so they have way more coming across their desk.
Right.
The lieutenant governor had other priorities, and many of them were good priorities around, increasing mental health beds, increasing power reliability, decreasing property taxes. So some of those were some of his priorities. You can't argue with any of that. But digital asset innovation was not one of them. Mm-hmm. And there's a couple senators that are actually like, not only are they not priorities, we're going to fight tooth and nail anything that you put forward in this. Mostly because and these are all Republicans, by the way, Republican senators, all of them, every one of them. We didn't have any opposition from Democratic senators. Now, I think there's only 11 Democratic senators in total in the Texas legislature, which would that put like 19 or 20 Republican senators. So they conflated it with central bank digital currencies. And so that's I think a low-hanging fruit for us to do some education on. But it's not as easy. Like, everybody listening to this podcast is immediately going to be like, oh my gosh, central bank digital currencies are like the opposite of what we're working for here. But to a senator in his or her fifth, sixth, seventh term, advanced in their career, they're like, oh yeah, that digital currency stuff, that's just the feds trying to get more power, or the government trying to get more power.
Yep.
So it was a unique dynamic that I think will surprise most people.
There's an old lobbying saying that there's only two types of legislatures: allies and potential allies.
There you go.
So our job is to reach out to those potential allies and bring them in.
Exactly, which is why we were very careful in our criticisms. I put out a video, I don't know if you guys saw it, we praised some senators for their service and for their defense of liberty and their constituents, and just said we think that they might be misinformed on this one, which is how we got to do it. You can't, if you come out swinging, you're just entrenching an enemy.
Yeah, absolutely. Well, and I mean, I think the one thing that I have learned over the course of the lobbying efforts that we've done on the congressional level is that any thought that these people are omniscient or actually can understand all of the things that they touch on a regular basis is impossible and is unrealistic.
Yeah.
And we shouldn't expect that of any human, let alone an elected official. So I think that the most important thing, which we both said already, is education and how to and who the best people are to do that education, placing the right. And this goes to a conversation I think we've had a lot over this conference season so far, is the industry has grown up so much, and a lot, I think, of this regulation and this enforcement action is a hangover from 4 years ago when frankly there was a lot of fraud going on. And it's just, that's how government it takes a really long time for the car to turn, right?
Yeah.
And so I think that this is just a hangover from all of that, when yes, the industry was new and there was some things some people did some things.
Yep.
And so now we just have to sort of say, yes, we know that you're still hung up about that thing 4 years ago. And, FTX didn't do us any favors in this category. But we now have an opportunity to say, look how far we've come. Look how grown up we are. Look how professional we were wanting to be. Like, please work with us. And I think that's really the message that we can take to legislatures. And again, it's about putting the people who are grown up and want to be want to play ball in front of those people to say it's not, the degens in the basements anymore. Some of that
lawyers,
still.
bankers, and accountants.
Yeah.
Yes.
And you're very innovative startup people. You're actual true innovators who just want to do cool stuff, who want to make cool technology to fix problems.
Absolutely.
What a concept.
Couldn't have said it better myself. Well, guys, we are at time. We've got to wrap up, but we could probably go on for another hour. Where can people reach out to you guys to find out more about y'all specifically and Carrington Coleman's digital asset practice?
Sure. So I'm Alex Moore. This is Monica Gaudioso. You can find us at ccsb.com, Charlie Sam Bravo. My name is Moore with one O, because everyone wants more. And then I'm also on Twitter at UTAMORE. We try and host weekly audio discussions about crypto law on 4 p.m. Central on Thursdays. We were doing it on Twitter. We're moving it to LinkedIn, but you can find the link on my Twitter, and I look forward to seeing y'all there.
All right, guys. Thanks for being here.
Thanks so much, Lee.
Thank you so much, Lee.
Hey, it's Amy. Click over here to subscribe. Click over here for more content, and we'll see you next time.